the final round of the 59th annual Theodore Reimel Moot Court competition. Obviously, it wasn't as planned, but we're proceeding anyway with our 4 fine competitors.
So just logistically, if you guys would be able to, please put laptops away, silence cell phones. We are in the Supreme Court of the United States for the next hour and a half of our lives. Okay. We have the fine justices of Chief Justice Brogan, Justice Agard, and Justice Lund who have stepped up to help judge these fine competitors today, and it's going to be a very hot bench and very exciting competition. Okay. We're going to get started in about a minute or two when the justices do arrive. This is a formal courtroom. Everybody does rise for the justices, and they will tell you when to be seated, and then the arguments will commence. Does anybody have any questions at this time? Wonderful. Thank you guys so much.
Thank you.
All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Justice Agard, Justice Lund, and Chief Justice Brogan now presiding. All those having business before this, the Honorable Supreme Court, make your presence known, and ye shall be heard. God bless the United States and the Honorable Court.
You may be seated. Counsel, are you ready to proceed?
I am, Your Honor.
Go ahead.
Associate Justices, Chief Justice, opposing counsel, may it please the Court. Good afternoon, Your Honors. My name is Scott Zlotnick, and along with my co-counsel Vanessa Huber, we represent petitioner in this afternoon's case. Your Honors, petitioner requests 2 minutes for rebuttal.
Fine.
Your Honors, this is a case about attaining equitable relief for a group of individuals who were defrauded by respondent. Your Honors, we will first ask this Court to affirm the 13th Circuit's decision and find materialization of the risk is an adequate way of proving loss causation. Second, as my co-counsel will explain, we ask this Court to reverse the 13th Circuit's decision and find we have met the class predominance requirement under Federal Rule of Civil Procedure, Rule 23b3. First, Your Honors.
When you say equitable relief, are you distinguishing between remedies at law and remedies in equity, or do you just mean it in the general sense, equitable relief?
My apologies, Your Honor. I mean this in the damages sense. I should have stated that clearly. Your Honors, first, this Court should adopt materialization of the risk as an adequate method of proving loss causation to prevent respondent from avoiding liability by failing to make a correct disclosure for 2 reasons. First, every circuit that has heard the theory of materialization of the risk has accepted it.
But are we bound by that as a majority vote? If the circuits say yes, we have to follow that?
No, Your Honor, you're not. The circuits are merely a persuasive opinion, but my hope...
What's persuasive about them? What's
Your
the
Honor,
most persuasive argument from the circuits?
Your Honors, 10 out of the 13 circuits have expressly adopted materialization of the risk as an adequate way of proving loss causation. The 2 circuits that have not expressly adopted it, the First Circuit and the 11th Circuit, have had lower court decisions where materialization of the risk has been found to be an adequate way of proving loss causation.
Those circuits that have accepted materialization of the risk as a theory, the specific loss causation theories in those cases, were they consequential damages or were they something like out-of-pocket damages?
Your Honor, it was a mix of those damages. Generally, it was out of pocket, but it was a mix of out of pocket and consequential. I'd be happy to provide you a supplemental brief later on with the specifics of that. But importantly, those courts that have adopted materialization of the risk have used this court's language in Dura, the 2005 decision in which you held that loss causation was a necessary prong of proving materialization of the risk. Now, what's important to note in that case is that the court used language that some have interpreted that you would prefer a corrective disclosure as a means of proving loss causation, and in subsequent decisions such as Halliburton 1 in 2011 and Halliburton 2 in 2014, this court stated a corrective disclosure as a means of proving loss causation, but at no point has this court expressly stated a corrective disclosure is the only way of proving loss causation. Specifically, lower courts have used this court's language in Dura about the relevant truth later leaking out into the market as a way of showing that this court would expressly adopt materialization of the risk.
But this court was also concerned in Dura with how directly connected the loss was to the misconduct. And in this case, we're struggling with that connection. I mean, it seems that materialization of the risk creates a proximate causation problem. How do we deal with that? And we expressed concern about that in Dura.
Your Honor, I do recognize that concern, and in Lentil, a 2005 Second Circuit decision, they touched upon that very issue about the attenuation problem. And what that court found was the materialization of the risk not only can be found in proving that there was some sort of fraudulent statement or misstatement or omission made by a corporation, but it had to be foreseeable. And in the specific case at hand, if I can direct you to page 2 and 3 of the records, respondent has made 13 misstatements over a 3-year period. And importantly, there was a 2007 explosion that occurred at one of respondent's sites. And as a result of that explosion, respondent hired an outside commission to examine the safety practices and procedures that were occurring at their mines. And that panel was supposed to make recommendations that respondent was supposed to implement. It was not until the explosion occurred that petitioners were made aware of the fact that respondent had not, in fact, implemented those safety practices and procedures.
And do we know that those safety practices, or the absence of those safety practices, is what caused? Because you can have a misrepresentation, but if it wasn't the things about which they made misrepresentations that caused the explosion, then we're back to a causation problem.
Certainly, Your Honor, and petitioner recognizes that there could potentially be some intervening causes. However, at the 12B6 stage, it is petitioner's duty to present the theory that it was plausible and that there was this proximate cause and that it was the fraud perpetuated on the market that was realized in this explosion. And what
if we accept the materialization of the risk, do you think that leads to higher pleading standards for what you have to plead when you're pleading that, in terms of that the absence of other factors and there was just this?
Your Honor, there actually is a current split within the circuits about that pleading standard. There's currently a split between an 8A pleading standard, which is a general pleading requirement, and a 9B, which is a fact-specific pleading requirement. And as the court stated in Lentil, we're perfectly willing to meet that 9B standard of a fact-intensive pleading requirement, which we believe we have made here. We believe the 13 misstatements and omissions that were made over that 3-year period directly were realized with this explosion. And if I could direct you to a case in the Southern District of West Virginia from 2012, which is in the 4th Circuit, which is one of the circuits that has expressly adopted materialization of the risk, and that is in Ray Massey. And in Ray Massey, that court found that under that 9B pleading standard, materialization of the risk was adequately pled when an explosion occurred, with an almost analogous fact pattern.
Do you have to sort of allege the absence of other potential explanations?
Your Honor, not necessarily at this stage. It is not our duty to provide the intervening causes. That's something that should be discussed at the district court level, at the lower court level. We just have to show that proximate cause and that connection between the fraud alleged and the actual materialization of the risk realized. And that is what in Ray Massey spoke to, where there were 29 miners killed, which is exactly what happened here. And importantly, in that case, the defendant in that case had made statements to the SEC that were fraudulent. And I believe that respondent will try to make the connection that if you aren't to adopt materialization risk as an adequate means and only adopt corrective disclosure, that the SEC can provide proper oversight.
Can I ask you a question about materialization of the risk? I mean, obviously in this case, the argument is that that you're making is that these misstatements indicated the risk is either zero or something close to zero. But what about a different case where the disclosures from the company were that there's a 50 to 60% risk of some event happening, not 100%, even though they might know that it was 100%. So it's a misstatement. Now, the fact that they're saying it's more likely than not that this event will occur, when that event ultimately materializes down the line, is it the same sort of case, or do you think there's a difference between the two?
Your Honor, I do think it's a slightly different case because in that situation, respondent will be making factual statements to their investors, which is what we don't have here.
No, but let's say that they know that it's a much higher risk, so it is a misstatement, right? So they know, in fact, that it's a 90% risk. So it's not a question, they'll be able to make those, I'm just wondering whether or not the amount of risk that is disclosed at the front end can be preclusive of a later question about fraud.
Your Honor, I certainly think that is a consideration, and that's why it is a fact-intensive inquiry where materialization of the risk, if adequately pled, wouldn't be across a class-wide basis every single time. We have to look at all the facts presented. And in that situation where it's known to the investors where this risk probability is higher, there is certainly a bigger issue. But in this specific instance, it was not known to investors about the specific risks they were investing in.
But I need to take issue with that a bit, because from what I've read, mining is risky. And it seems that this particular risk occurred. I think, Justice Lund's suggestion that you could say 50%, 100%, 70%, I think that's really kind of nonsense on stilts. It seems that the problem with materialization of the risk here is there's always a risk of explosions. Explosions happen. Mines blow up. Mines collapse. Methane poisons miners. There's so many things that could happen. Mining is a risky business, no matter what safety precautions we take. So I'm struggling with materialization of the risk being an appropriate measure, especially here in a context where risk is just inherent in the investment decision, period.
Your Honor, I recognize your concerns, and I know in both during 2005 and in Telebs in 2007, you spoke to those concerns about providing a broad insurance policy. However, what petitioner believes is that if corrective disclosure is the only means of proving loss causation, respondents in future cases will have no incentive to ever issue a corrective disclosure. And when they've perpetuated fraud upon the market for a long period of time, the truth will never actually come out. And as stated in Ray Coca-Cola, which was a case in the Northern District of Georgia in 2007, and it was also articulated in Ohio Public Employee Retirement System, which was a case in the Sixth Circuit in 2016, should a corrective disclosure be the only method of proving loss causation, eventually the truth might come out. However, it won't come out until down the line when the truth is walked out with other facts that are going to muddle the very fraud that's been
perpetuated. Doesn't that assume, though, that the SEC is powerless or toothless? I mean, doesn't the SEC tease out the untruths?
Your Honor, that actually brings me to my second point, that by accepting materialization of the risk as an adequate way of proving loss causation, this court would be going in conjunction with Congress's intent when enacting the 34 Act and the SEC's later promulgation of Rule 10b-5, as Rule 10b-5 was created to prohibit sellers of securities to use or employ any manipulative or deceptive practices, which is exactly what happened here. Respondent issued 13 misstatements over a 3-year period. They perpetuated fraud upon investors multiple times, and in fact, if you note on page 2 and 3 of the record, they issued misstatements to the SEC. So yes, the SEC does provide broad oversight. However, in this situation, the SEC couldn't actually see the fraud because respondent committed fraud to the SEC. So there is an issue if respondent's not being truthful with the SEC, how can they provide proper oversight? Your Honors.
Well, doesn't the SEC rely on its sister agency? So the Bureau of Mines should have been doing its job. If the Bureau of Mine Safety had been doing its job and gone in and discovered that they weren't complying with the safety regulations, then the SEC would know there was disclosure. I mean, I know that we wanted this to be a remedy that would provide for private prosecutors to help the SEC, but do we need to shoehorn in this somewhat difficult cause of action, way of establishing a cause of action, changing our notion about requiring disclosure in order to deputize private attorneys general, or do we just leave it to the SEC and the Bureau of Mines?
Your Honor, I believe that if you leave it to the SEC and the Bureau of Mines, again, we have an issue of they're providing this broad oversight. They can't necessarily see every little action that's going on within a corporation, especially in this situation where respondent has lied to those very institutions. And I believe what you're speaking to in part is this court's decision in Santa Fe in 1977, where this court stated that a 10b-5 claim was specifically for fraud and not about theories of mismanagement or a breach of fiduciary duties. But if I may, the Second Circuit in Suez in 2001 stated that in a situation like this, we aren't alleging a mismanagement claim. What we are looking at is that the investors were lulled into believing by respondents' deceptive practices that their investment was safe. And had they known the potential harms that were occurring at these mines, they would have actually looked into it before investing. And that the fact that they were lulled in.
What's really going on here, though, that every time that there's an accident like this, someone and the investors feel a loss, they're going to allege false statements. They're going to parse through every little statement that the company has made, allege a false statement. And even if it's not really false, because they suffered the loss, they'll pursue it. And in most of these cases, it's not going to go to trial. They're going to wrench some sort of a settlement out of the company. And so really this is just a way of getting companies to insure against their losses by paying the investors, isn't it?
Your Honor, I do recognize that concern. However, as I stated before, if a corrective disclosure is the only means of proving fraud, in this situation, fraud has been perpetuated. And if I can direct you to that previous case, I stated Ohio Public Employee Retirement System. That case involved Freddie Mac and the subprime mortgage crisis. And in that situation, the investors had no idea that their investments were being made with the subprime mortgage housing market. Freddie Mac led them to believe that their investments were safe. And in that situation, the materialization of the risk occurred when investors lost $2 billion. Now, in that situation, we show that is a great example of how if...
But I think the distinction, and I think this is part of what both Justice Agard and I are struggling with, is there's a distinction between banks and financial institutions, which we assume, absent widespread fraud, the regular course of business is they're relatively safe investments. Mining is never a safe investment. So relying on safety, I'm struggling with why this is the only way we can make them whole. It's not the same thing as Freddie Mac, because Freddie Mac, there was wholesale fraud going on behind the scenes. Not what we would expect. We absolutely expect mines to blow up.
Your Honor, I do recognize that, and as we stated from the outset, the materialization of the risk also has to be foreseeable. I see I'm out of time. May I finish your question? We recognize that this does have some potential issues. However, in this specific situation, we had a 2007 explosion. And as a result of that explosion, an independent commission was hired to examine the safety practices and procedures that were going on at this mine. Had this been the first explosion, I would recognize the concerns here would be a lot higher. However, the fact that we had this first explosion, that there was an independent counsel hired to examine those safety practices and procedures, the fact that that panel was supposed to implement those safety practices and procedures and were supposed to make those mines safer, and it was not realized until this explosion that those very safety practices and procedures were not going on, fraud was committed. And importantly, 29 people died as a result of this fraud.
But that's not what this is about. This is not about 29 people dying. This is about your investors losing money that they were hoping they wouldn't lose.
Yes, Your Honor.
29 people is totally irrelevant.
It is somewhat irrelevant, Your Honor, but it is important to note that the fraud perpetuated by the respondent did not just harm the investors, it harmed actual people and lost their lives. In conclusion, Your Honors, this court should adopt materialization risk as a valid way of proving loss causation. As if a corrective disclosure was the only means of proving it, the respondent would avoid liability. Thank you very much.
Ready to proceed?
May it please the court. Good afternoon, Madam Chief Justice and Associate Justices of the court. My name is Vanessa Huber, and as my co-counsel stated, we represent petitioners in this case. This is a case about ensuring fairness in securities fraud actions where a number of individuals have all been harmed in the same manner by a large coal mining company.
Tell me about that matter. I understand that your co-counsel called materialization of the risk as the way of proving loss causation, but it's more than that, right? It's materialization of the risk that then leads to some specific way in which your clients lost, and you're saying they all lost in the same way. What way specifically did they lose? Did they lose by paying too much for the securities, or did they lose by buying the securities in the first place?
So, Your Honors, that brings me to the first of my 2 points in this argument is that petitioners all use fraud on the market as their presumption of reliance upon these misrepresentations. And as this court stated in 1988 in Basic Inc. v. Levinson, they established that fraud on the market is a rebuttable presumption of reliance. Now, it is important to note, however, that on page 11 of the record, respondents have already conceded that we have met all of the requirements of fraud on the market in order to prove that petitioners have adequately relied upon the price
But
of
how
the
does
stock.
that connect with your measure of damages and the problem with the class certification? Because fraud on the market would assume relatively similar differences in loss. And here we have a situation where we're talking about very different notions of risk. I mean, more risk averse, less risk averse. Would this person have paid more or less? It just seems that this part of the argument is somewhat inconsistent with us certifying the class.
Yes, Your Honor. So I believe that brings me to the point that the 13th Circuit did rely on Comcast Court v. Barrand, this court's decision in 2013 that the 13th Circuit believed we needed a class-wide damage model in order to grant class certification in this case. However, it is important to note that the 13th Circuit erred in requiring that Comcast's class-wide damage model requirement be applied to the facts of this case at bar.
I understand, but what is your damage model? Is your damage model exclusively consequential damages that your class, your clients would not have bought but for the lie? Or is it some sort of mixed model where it's some would have bought but for the lie, would not have bought but for the lie, whereas some would have but would have paid a lesser price but for the lie? What's the model specifically?
So, Your Honor, at the top of page 10 on the record, expert Jane Kaufman posited a consequential damage model.
Okay,
So
if that's true, here's my question. Basic, as you've quoted, presumes that in order to get reliance for a class, in order to make 10b-5 a robust disciplinary mechanism, because the SEC perhaps cannot police, it assumes that everybody relied on the price, not on the lie in order to buy the security. So it bakes in this notion of price reliance in order to allow for classes like yours to proceed. But yet you get the benefit, as you say, the respondents have admitted this, you get the benefit of basic by which smuggles in this price distinction, that only the price distinction. That's the only thing that makes sense. Otherwise, you wouldn't be able to have commonality among the various investors, right? But now, in the second stage, when you get to loss causation, you want to disclaim price reliance, and you want to say, no, it's not about price reliance. It's rather about we wouldn't have bought in the first instance. So doesn't that get rid of basic in this sort of, if you're going to take that kind of loss causation angle on a class certification question, don't you lose basic?
So, Your Honor, I believe there are 2 points I can touch on in response to your question. The first point is that loss causation need not be discussed at the class certification stage. That was actually granted by this court in Halliburton 1 in 2011. The second point I would like to point out is that basic is not necessarily rendered invalid through our assertion of fraud on the market in this case. It is merely our theory of liability that petitioners have set forth. Petitioners on page 3 of the record have alleged a 10b-5 claim based on their assertion of fraud on the market in reliance upon the materialization of the risk claim. And Your Honors, it's also important to note that the 13th Circuit did not hold that there should be a theory of liability that is tied to the theory of damages, as actually a majority of circuit courts post-Comcast have interpreted the true meaning of Comcast holding to be that, instead of requiring a class-wide damage model. So petitioners are setting forth the argument that they have presented an adequate method of a common question that predominates over any individual questions of damage issues or presumptive risk differences based on the fact that they have this one giant common theory of liability that they have all been defrauded via respondents' misrepresentations.
But that's where I have my causation problem, is you're sort of sliding between, don't worry what this hand is doing, because right now we're talking about materialization of the risk and how we would establish that. But then when we get over here, it's like, oh, don't worry about that, because we have this overarching notion of everybody's doing the same thing, except we're not, because we can't prove that everybody's doing the same thing. I'm finding an internal inconsistency that I have to reconcile before I can grant the be willing to grant class certification.
So, Your Honor, if I may draw your attention to a quote from the Ninth Circuit in 1975 in Blackie versus Barrick, which was also requoted again in a post-Comcast Ninth Circuit opinion in Leva versus Medline Industries Incorporated. This court, the Blackie court, was stated by saying that the amount of damages is invariably an individual question and should not defeat class predominance. And petitioners would like to draw a similar parallel to risk in securities actions. And in fact, Chief Justice, I believe you had stated this earlier to my co-counsel, that risk is invariably a question in any securities transaction. And that individual question, petitioners are asking that that individual question should not preclude class predominance.
But even if risk varies or damages vary, doesn't Comcast say that there has to be consistency between how you establish the fraud and how you measure damages? So not that the damages have to be the same across all plaintiffs, but that your model has to match up with your liability model.
Yes, Your Honor, and that is correct. But Justice Scalia also did note in Comcast that the damage theory just cannot calculate damages that are not the result of the wrong. So in Comcast, there were four theories of liability that were initially proposed by the plaintiff class seeking certification. And 3 of those 4 theories were rendered invalid or simply not true in that case. Now, what's important to note in that case, however, is that the damage model presented by the expert in that case, the expert conceded that it was not attributable to one sole theory of liability, and it had to account for all 4 theories taken together. So when that court realized that there were 3 theories that were untrue, it rendered the entire damage model invalid.
But it seems to me that's exactly what we have here, because you have a liability model that's based entirely on one group that would not have bought, but you have a damages model that has 2 groups in it, only one of which is representing the liability. So it seems like this is exactly Comcast. Your liability models don't map onto your damages models.
Your Honor, we would respectfully disagree. Based on the damage model we have set forth, it is the only damage model with the facts presented in the record as we have them to adequately account for.
I think we understand that the only way you can get just compensation for your victims is your damage model. But your damage model is not consistent with your theory of liability for all of your damage model for some of your victims is not consistent with your theory of liability, and that's where the disjoinder is.
Your Honors, we believe that the common theory of liability is what rings true here and what holds more bearing in determining whether or not we have satisfied the predominance requirement. Many courts post-Comcast have also stated not only that there is a theory of liability that is tied to a theory of damages, and that is what Comcast's true holding is actually meaning, but there are 5 circuit courts post-Comcast that continued by stating that damage calculations can be determined or figured out after class certification as long as there's one common theory of liability.
Can I ask about the common theory of liability? There seems to me to be an easy way for you to resolve this issue, which is to avoid consequential damages and instead look for out-of-pocket damages. That might require you to hire experts who are able to disaggregate the loss caused by the actual accident versus the loss caused by the disclosure that's made by the accident. But why would you choose consequential damages, which leads you into this thicket that my colleagues are describing, and not just go out-of-pocket damages?
Your Honor, consequential damages is the only way for those supposed low-risk people in the petitioner's class to recover the entire fall in the stock market price.
How many are there? I mean, most people, and I don't want to assume that I'm like everybody, but we invest through our 403b or our 401ks. These are diversified portfolios. The idea that we're avoiding risk and won't invest in risky projects, it seems like a story out of 1960, not 2018. I mean, you've brought your case to a grinding halt on this issue, which is incredibly difficult, on the basis of a handful of undiversified investors. That strikes me as not appropriate.
Your Honor, petitioner, there's a very scant amount of facts for petitioners in the record. In fact, on page 1 of the record, there's just merely one phrase about petitioners, that they have all bought common stock and respondents' stocks. Unfortunately, there's not more facts to really discern the differences between supposed levels of risk, or how many or how much money they even spent on these stocks. However, that brings me to my second point, which is that petitioners would likely not have the effective strength to bring suit against respondents as individuals if it were not for this grantal of class certification. And it's important to note that the Advisory Committee on Subdivision B3 stated specific instances that would be ideal for class certification. And one of those is that an instance of fraud perpetrated on numerous individuals by the use of similar misrepresentations, which is exactly what we have seen on pages 2 and 3 of the record here. And what's also more important to note is that the advisory committee continued by stating that class actions are still practical despite the need for separate determinations of damages.
Can I ask you? Oh, go ahead.
Could you limit the class to those whose damages model matches the liability model? So in other words, is the choice not necessarily between the way you've done it and individual suits, but just a more narrowly tailored class?
Yes, Your Honor, we believe that is possible after class certification when in discovery or in trial there are more facts that can be found on the petitioner class, and we would be happy to either decertify later if the court finds that it is too strenuous, or we would be happy to bifurcate liability and damages with a 23C4 or by creating subclasses. In fact, the Fifth Circuit in Re Deepwater Horizon post-Comcast did exactly that and divided into subclasses after certification once they realized that there were two specific different...
But again, that would assume that a subclass assumes that this class gets to recover based on your theory of recovery. And I think what we're struggling with is you may have some part of your class, pardon me, that can recover, but that these people get jettisoned.
Right, they'd have to be excluded altogether rather than just partitioned from the other
Because
subclass.
the problem is, we have lots of problems, but we're not now talking about the problem of differences within a class where a subclass would help. We're talking about this group of people don't flow directly from your allegation, your theory of the case.
So, Your Honors, based on fraud on the market and its reliance upon materialization of the risk, we do know one thing, which is that all petitioners have at least been harmed and defrauded and have lost to the extent that the misrepresentations artificially inflated the stock market price. And every petitioner in this class is rightfully supposed to recover at least the difference between what the misrepresentation caused that artificial price to inflate to and what the actual stock market price would have been if it were not for those misrepresentations.
I'll confess, that sounds persuasive to me. So my question to you is, if that's true, and we already know, unlike the Deepwater Horizon, we already know there are two oppositely situated groups, why would we certify the class and then hope that we get to that point afterwards rather than split the class now and certify them each?
Your Honors, based on the facts set forth, we believe it would be unfair at this point to subdivide the class based on the scant amount of facts. Petitioners are asking that with the consequential damage model, we do know there has to be at least a certain amount of individuals that are not only entitled to recover that difference in price, but also the full drop stock in the price after the explosion in 2012. So petitioners would like to state a quote from In Re LTV securities litigation from a district court out of the Fifth Circuit, in stating that the specter of thousands of mini trials and damage amounts does not seem sufficiently palpable to override the economies of a single trial, which petitioners believe that if this court were to find that we are meeting the requirements, I see that I'm out of time, may I briefly conclude? If this court were to grant or find that we have met the requirements of class certification, we believe that it would not only achieve economies of time, effort, and expense, as the advisory committee has stated, for petitioners, we also believe that it would do the same for the courts in finding that it would be easier to deal with this litigation in one suit, in one class, or maybe divisions of subclasses later down the line, instead of dealing with each individual member attempting to bring this claim as individuals, one by one. And for those reasons, we ask that this court reverse the 13th Circuit's decision. Thank you.
Good afternoon, Madam Chief Justice, Associate Justices, and may it please the Court. My name is Rodrigo Rivera, and along with my co-counsel, Kaylin Wernitsnig, we represent the respondent, Mason Energy Company. This case is about this court following its own precedent in not recognizing a diluted theory of pleading loss causation, which would open the floodgates for unmeritorious litigation. This court should reverse in part...
Do you contend that this is unmeritorious litigation, this particular case?
Your Honor, there are things that are cause for concern with this litigation. However, recognizing materialization of the risk as
But do you think this is an unmeritorious case?
I believe that this is a frivolous theory under which to bring loss causation, which would not connect the alleged misstatements to the economic harm, which is exactly what this court chose to not allow in a unanimous decision in 2005 in its case Dura.
Can I ask a question about corrective disclosure?
Yes, Your Honor.
Imagine the case is different. Imagine that the mine explosion happens, and then immediately or 2 days later, your client discloses. So there is a corrective disclosure. You get the experts, they do their event studies, and they look at when things happen. And you're going to say, you're saying the plaintiffs only can look at the corrective disclosure. That's going to be the event. And that event study is going to show that there is no price effect by the corrective disclosure. Correct? You agree? And therefore they're not going to be able to show loss causation. On the other hand, it's clear that in that corrective disclosure case, right, the corrective disclosure was related to the loss because the loss has already occurred. So I know it's the parade of horribles that the petitioners, that nobody will ever disclose, but it actually is a get out of jail free card or get out of liability free card to disclose after the event is what you're suggesting. Because you might get through a 12b6 motion, but by the time you wind up actually figuring out what the damages are, the damages are going to be zero if you're only relying on corrective disclosures.
Not quite, Your Honor. I believe that what corrective disclosure allows for is for there to be a direct link associated between the economic harm and the alleged fraud. And that's exactly what this court wanted to be the case in its case Dura.
What would be, in my situation, what would be the harm that the corrective disclosure would show? That day, Monday the explosion happens, Wednesday the corrective disclosure happens, you look at what happens to the stock price on Wednesday and nothing has happened because everybody already knew what happened because of the explosion on Monday. So then we come to court, they bring the case and they say, we can't show loss. You then say, you can't show loss causation. They say, well, yeah, because it all happened on Monday. So is that a workable solution?
Your Honor, in that particular case, it would seem that there wouldn't be loss causation to begin with because of the fact that there was no economic harm. There needs to be economic harm.
There is I think that's the problem. That's exactly the argument we would make. There is significant economic harm. We invested because we thought you were a safe, upstanding mining company. You lied, you weren't. Therefore, the mine blew up, the stock price drops, and you say on Wednesday, by the way, we lied. But if we have to tag only to disclosure, and disclosure happens after the event where the risk was materialized, the disclosure causes no drop in the price, therefore it's, as Justice Lund said, get out of jail free card.
Your Honors, the issue, it seems to me that a corrective disclosure would cause some type of drop in price solely because it would reveal to the market a fraud and that automatically creates some type of price drop. And in this case, if that's not the case...
But you don't think the market can infer fraud based on prior statements, knowing that prior statements were made about safety? They see that does not realize. They don't know for sure. But the price drops based on some combination of the loss of assets. The mine is less valuable, obviously, but also in some sense that maybe other parts of the company are less safe than we thought before. So that you don't think that you think it's only coming from the market, the disclosure by the company? That's the only information that's seeping into this?
Your Honor, that's a precise issue with materialization of the risk. Materialization of the risk is so attenuated that even in this particular case, the mine in and of itself, which is what petitioner points to, breaks the causal connection. So in fact, what you are stating is the exact issue with materialization of the risk. Because there
breaks the causal connection between what and what?
Between the economic harm in this case and the alleged fraud.
No, it causes the economic harm. Right?
Your Honor,
it causes the loss.
Your Honor,
that is when the loss happens. Is mine explodes, next day it craters. The stock price craters.
But, Your Honor, you're correct that is what the theory states. But the mine in and of itself isn't.
But if the market is working rationally, that's what should happen, right? We don't wait around to say, oh, it turns out our mine wasn't super safe like we said it was. We know it's not because it exploded yesterday.
That is correct, Your Honor. But Mines are inherently unsafe and risky, as the Chief Justice mentioned to opposing counsel. So what I'm saying when I'm saying that the mine in and of itself is a factor that could have broken the causal chain is that in your own precedent, you require the economic harm to be tied to the alleged fraud. A fraudulent...
Well, and of course, without getting into the damages issue and the class certification issue, which is a separate issue, the problem is you're trying to disaggregate two things that can't be disaggregated. You're right, and I said it a moment ago, although I was persuaded by counsel's argument. Mines are dangerous. So I am saying I'm not going to invest in a mine until we have Mason come along and say, we are a safe mine because we spent a lot of money and put all these safety things in place. So I, based on that, say, safe mine, they told me they were safe mine, that's the lie. That's the lie that the disclosure is aimed at. And the fact that it blew up before it blew up and then we corrected it doesn't break the causal relationship. The causal relationship is, you said it was a safe mine, it wasn't a safe mine. We either discover it wasn't a safe mine because you tell us we lied, or we discover it wasn't a safe mine because it blew up before you told us. This is worse in my mind, but because of the 29 miners. But it doesn't break the causal connection at all. It is the very thing that the lie was explicitly designed to get me to invest by making me think it was safe, when it turns out it wasn't. It's just a matter of how did I discover it was unsafe? I discovered it was unsafe because it blew up, or I discovered it was unsafe because for some reason you decided to disclose. No causation problem.
Your Honors, this case in Dura mentions various factors that in and of themselves would not allow for the inflated purchase price theory in that particular case to reach the necessary pleading standard for loss causation.
That's because they didn't plead that the stock price actually dropped. I mean, it was just bad lawyering on the part of the plaintiff in Dura. They failed to say, and by the way, we bought it at an inflated price and the stock price didn't drop. But they said, and by the way, the stock price dropped, we don't even see Dura. They are saying the stock price dropped. The stock price dropped when the mine exploded. It's not Dura, right?
That's incorrect, Your Honor. I believe that though here there may be a price drop, unlike there was in Dura, the factors that intervene are the exact same possibility here. In other words, there could be changed economic circumstance, regulatory circumstances, price volatility. What about the geography?
Can't you adjust for that with the experts that we know are available for this? So you can adjust for, there were some changes and we can look at other mines and say, well, yeah, everybody suffered because people finally figured out global warming's a thing. And so everybody's price dropped a little bit. But your price dropped a lot more because, oh wait, the mine exploded.
Your Honor, that still does not prove the isolated link necessary in Dura. Dura requires that connection to be a close causal nexus.
But
so
it's
as
not
to
like you're only going to have intervening factors in materialization of the risk cases. I assume that if you had a corrective disclosure here, you would still be trying to argue intervening factors and that the whole loss wasn't caused by the misstatement, right?
No, Your Honor. What a corrective disclosure does is exactly mark a date through which we can then show a market loss. So as to isolate, when this happened on X date, there was X drop in the price.
Can't the mine explode
But
the same way?
let me try to phrase this. It's not that you're not making the claim, I take it, that there's no new information that comes into the market when the mine explodes. Rather, you're saying that there's lots of information that comes when the mine explodes. One, that the mine exploded. Two, that probably the company lied about it, or maybe the company lied about it. And so that stock price drop represents any number of things, but only a portion of which is related to the lie. And that gets back to the Chief Justice's question, which is, can't experts disaggregate those two pieces? Forget intervening events, forget interest rates going up, the Suez Canal being blocked, whatever it might be. Just those two pieces. The actual harm to the company's assets, to the company's DCF analysis, because the mine has exploded, and then a piece that's attributable to the loss that's based on the lie.
Your Honor, this is exactly why respondent would like this court not to recognize materialization of the risk. There's judicial economy concerns, as this court stated in a unanimous decision in Dura. Basically, the congressional intent for a 10b5 cause of action is to not create a broad insurance policy for any loss in the market, but rather solely losses that have to do with deceptive, fraudulent behavior. To take the time and force a corporation to go in to trial solely to try to bring in experts to try to create isolation would force the arm of a corporation to settle out of court even when there isn't meritorious litigation to be had.
Doesn't that then leave us in the situation that it's clear from the history of the SEC and how we want to enforce these causes of action, we're relying on the goodwill of the companies to make the disclosures. And we don't have the horses to go in and find out. The SEC certainly can't figure out whether or not Mason is lying. So if we rely just on the disclosure, why would anybody disclose?
Your Honor, there is a couple reasons why a company would choose to disclose. First off, your stock price has to do with your reputation. It is in the self-interest of a corporation
to wreck its reputation by disclosing that it lied?
But it creates an opportunity for transparency further down the line where where investors would know that they have the reputation that if they are fraudulent and if they know that they've affected the market, as this court has defined in Santa Fe, which limits 10b5 causes of action to solely fraudulent deceptive behavior. In other words, actions that artificially affect the market price.
Those reputational incentives are so strong that they cause your client to lie.
Your Honor, do you mean that no, I'm
claim
saying...
is that the reputational incentives encourage disclosure, encourage truthful disclosure in order to get your reputation out in the market, in order to get investors. And yet, allegations that we have to take on face value at this point, are that your client lied. So how is it that we can rely on reputational incentives when we actually have evidence in this case, if we take their pleadings to be true, that those reputational incentives are not, in fact, preclusive of misstatements?
I mean, I would even flip that around and say the reputational incentives are so strong that you just say everything's rosy all the time because you're constantly trying to burnish your reputation.
Again, Your Honor, but if that is true, then there would be that could not be the case, because then there would be investors would know that this company would not be honest to the market. In other words,
do we need 10b5 then? I mean, there are academics who maybe you met in law school who claim that we don't need anti-fraud enforcement because the downside of lying is too great, the market will correct. It sounds a little bit like what you're suggesting. Should we just get rid of 10b5 as a private right of action completely?
No, Your Honor. In fact, I think 10b5 is a very meritorious claim if we truly can show that there's a connection between the economic harm and the alleged fraud, which is not shown through materialization of the risk. Respondent?
If we can rewind the clock, get Superman to turn the world backwards, and your client lied, and the mine didn't blow up, and then your client disclosed, oops, we lied, would you be here arguing that we shouldn't have 10b5 because the market will correct itself and it corrected itself? And
Your Honor, I think that a corrective disclosure would solve the problem that materialization of the risk creates. It solves the connection.
Your client would have disclosed if the mine hadn't blown up?
I cannot speak to that, Your Honor. I do not know what my client would have done, but I believe that my client, for its reputational purposes and to foreshorten the fraud period under which they would have to recover if fraud was revealed, they would have disclosed.
So it's not a coincidence that they disclosed the day after the mine blew up?
If they had disclosed, Your Honor, you're saying it would have been...
Yes, if they had disclosed, it would be only coincidence that they disclosed the day after the mine blew up.
No, Your Honor. I think it's true that obviously, as the Justice mentioned, a mine reveals something new to the market, a new factor, and that's an incentive in and of itself to disclose to the market. And so I think here what we need to focus on is that respondent is sympathetic to the losses by the investors and the petitioners. However, it is not a fraudulent cause of action. It could be mismanagement. It could have happened because of price volatility. It could have happened from breach of fiduciary duties, all of which they are free to go down and bring a different causes of action
But
in
you're
the
not,
future.
and that will get resolved at the next stage when we get to summary judgment, whether or not the misstatements are linked to the actual loss causation. There's nothing about materialization of risk, correct, that necessarily precludes this. Your suggestion is that the materialization risk requires too much judicial resources and resources of lawyers to be able to disaggregate these points, correct? That's the only thing that you're really concerned about.
My time is up. May I conclude
Yes.
by answering your question? That is correct. That materialization of the risk is so attenuated that it would cause corporations to have to settle when there is faint hope of discovery of a cause of action through the expensive means of discovery, which is exactly what this court was trying to avoid in its unanimous decision in Dura. Recovery solely through discovery is not what the statute's about. It's solely about creating confidence in the market and avoiding fraudulent, deceptive behavior. Thank you very much, Your Honors.
Good afternoon, Madam Chief Justice, Associate Justices, and may it please the Court. My name is Kaylin Warnitsnik, and I represent the respondent, Mason Energy, in this matter. This case is about following this Court's well-established adherence to stare decisis and the judiciary's role of limiting relief only to claimants in class actions who have suffered actual, measurable harm.
Are you suggesting that these individuals have not suffered harm?
That's not respondent's position, Your Honor. Respondent is stating that the class as it stands today is not sufficiently cohesive as to warrant class adjudication. This court has held that plaintiffs have the burden of affirmatively demonstrating their compliance with Rule 23 prior to class certification to prevent the abuse of frivolous lawsuits targeted at deep-pocketed defendants who are pressured into substantial settlements. Respondent respectfully requests that this honorable court affirm petitioner's denial of class certification for 3 reasons. First, petitioner failed to demonstrate that their damages model was capable of class-wide measurement because individual damages questions outweigh questions common to the class. Second, petitioner failed to affirmatively demonstrate that their theory of liability was consistent with their theory of damages as required by this court in Comcast. And third, this court's holding in Comcast stands for the straightforward application of class action principles and therefore applies.
Straightforward about Comcast. we have been struggling with Comcast. The circuits have been struggling with Comcast. I'm not sure anything that Comcast gives us a straightforward analysis that would apply to this case.
This court's holding in Comcast was clear that petitioners seeking class certification must prove that common questions predominate among the class and that their theory of liability is consistent with their theory of damages. Here, that is not the case. Here, petitioner's consequential damages model requires an individualized inquiry into the subjective intent and individual risk threshold of each investor, and therefore is not applicable for class-wide measurement.
Would you be all right if we kicked it back and allowed them to bifurcate the class, as was suggested earlier in our questioning of the petitioner?
Yes, Your Honor, that would be within this court's discretion to vacate and remand to allow petitioner to amend their complaint. However, as petitioner
But if we said we're sending it back and we're bifurcating, now we go forward with the class action, would you concede that would be a just result?
Are you asking if we were to divide the class into the subclasses here?
The 2 subclasses.
Your Honor, that could potentially alleviate some of the issues here. However, even within those 2 subclasses, you would still have to conduct an individual inquiry into each investor's risk threshold. Just because someone may have invested, it doesn't take into account that at what point of risk do they start investing and stop investing. And because of that individual inquiry that would need to be conducted, it still is not appropriate to...
So isn't that going to be true in every securities fraud case?
No, Your Honor. In this case, petitioner brings forth the materialization of the risk theory, which presumes that each investor would not have relied or would have invested at all.
But not in our bifurcated class situation, right? If we kick half of them and say they would have invested, but they would have invested at a lower price, then it's just a normal run-of-the-mill securities fraud class action. And to that point, your response to Dean Agard would be what?
That their damages model still is incapable of measuring either class because petitioner brings forth a consequential damages model which seeks the recovery of the entire fall of the stock price. And as your honors noted, and as this court has held in affiliated citizens, that the out-of-pocket damages model is the appropriate metric for measuring damages in a 10b5 cause of action because it seeks to determine the amount that the investors arguably overpaid by virtue of the value of the unpriced risk.
So is your argument that you could never have consequential damages in a securities class action?
No, Your Honor. It's respondent's position that when the theory of liability falls under materialization of the risk theory, that it is inappropriate and cannot measure damages across the class, in particular with consequential damages. And as this court has noted, that in order to be in accordance with the congressional intent and not provide a broad insurance policy, that a purchaser of security may only recover the difference between the price paid and the true value of the security at the time of the purchase. So here, where as petitioner brings forth a consequential damages model, would allow these plaintiffs to recover not only the damages attributable to their theory of liability, but any natural drop in the stock price, which this court has noted in Dura. There's numerous other factors.
Isn't that the kind of thing that is expressly left to the trial court to you raise that and say it wasn't this, it was that? It's these details that we should not be getting to at this level. We should be saying predominant, there's a predominant theory, there's a predominant model. We're not going to get into the nuts and bolts. They should have their chance. They have their chance in court, and you answer the questions.
Yes, Your Honor, and as this court has noted at Amgen, that while the likelihood of success on the merits should not be considered at the class certification stage, courts have a duty to perform a rigorous analysis to ensure that these have been met. And if any measurement of damages was acceptable so long as it can be applied class-wide, no matter how arbitrary, would reduce the Rule 23b3's requirement to a mere nullity. So if we don't apply this standard here and let any damages model in, there would be no point of having Rule 23b3.
What do you understand predominate to mean? Meaning, what goes into the denominator that is being compared here? Because there seem to be a lot of things that are in common. In fact, you and your, I don't know whether it was you or your prior counsel, admitted to commonality, typicality, etc., which, frankly, I was kind of startled at after I read the record. But you did. And what's the denominator here? How much variation among investors in this case is permissible before we must kick it out of class certification?
Yes, Your Honor. Well, as this court has already addressed numerous of these concerns, and in Halberton 2, this court has held that reliance alone across the class is not enough to warrant class certification, nor in Amcan, this court has held that it's not enough that claims are framed by a common harm or injury to warrant certification. So the predominance inquiry begins with the underlying elements of the claim, which in a 10b5 cause of action is economic loss. So plaintiffs have the burden of demonstrating that they have suffered economic loss.
That's only one piece of the 10b5. So misstatement, materiality, reliance, which you guys have admitted, right? You're not making a basic a claim that this falls under one of the exceptions to basic. So we've got materiality, misstatement, we've got reliance. All that's left is loss causation, so that's 3-1, isn't that? And even in that one, you said that you're okay with out-of-pocket damages being bifurcated, and that group at least doesn't even seem to have any problems with respect to the fourth, loss causation. It feels like predominance to me.
Oh, well, no, Your Honor. And I'm glad that you brought up the reliance question, because under this materialization of the risk theory, petitioner rebuts that presumption of reliance. And as Your Honor noted, that when an investor who invested because of the risk assessment, and as you mentioned, because I think this mine is less risky, I'm going to invest, and not relying strictly on the market price, the fraud on the market theory cannot be applied here, because fraud on the market does not provide any presumptions with regard to loss causation. And here, where the economic loss depends on the posture of each investor's risk tolerance, loss causation nor damages can be presumed.
I have to say I'm sympathetic to your claim. Did you bring this up below? Because that doesn't seem to be part of, as far as I understood the record, you had already admitted the basic reliance presumption, that was conceded.
That was conceded by respondent. However, under the materialization of the risk theory, petitioner themselves are rebutting it. And while that's more of a merits inquiry, because as it stands today, it cannot be applied on this class-wide basis, petitioner themselves are the ones rebutting it.
I agree with you. I think, or maybe I don't agree with you, but I'm close enough to say that it's plausible that these two are inconsistent. My question to your opposing counsel suggested. But this is being brought up now. As far as I know, this is foreclosed, no?
No.
This wasn't, it's not as though they're bringing up materialization of the risk for the first time in front of us. They brought that up below too, when you conceded reliance under basic.
Well, Your Honor, and as the lower court mentioned, and as a standard of review here is an abuse of discretion standard under this court's jurisprudence, and as petitioner concedes, that this court reviews denial of class certification for an abuse of discretion. And here, the lower courts applied this weighing test, the predominance inquiry, and they found that they did not satisfy the predominance inquiry. And appellate review of class certification should only be reversed if there's a clear abuse of discretion, which here there's no evidence in the record that suggests that. And on page 4 of the record, the appellate court they applied no opinion as to the merits, and they reviewed only the substantive and procedural inquiries in this case, and therefore their analysis was in line with this court's jurisprudence and Rule 23.
But if, for example, the lower court thought that you needed to have predominance as to all of the elements, and we instead decided that, 3 out of the 4 is sufficient, that would be an error of law that the lower courts made, and that would be treated de novo, correct?
Your Honors, if there was a clear misapplication of the law, that could be reviewed under de novo standard, but even under a de novo standard here, petitioner did not satisfy the predominance inquiry, because in this case, the common issues will not be predominated because there's going to need to be individual factual determinations of each investor's subjective intent. And when there's a lack of objective criteria to measure that, certification should not be proper.
That's only as to a very small piece of the case, right? So this goes back to Justice Lund's question of if there is predominance as to the majority or a supermajority of the elements that the petitioners would have to prove, isn't that predominance even if you don't have predominance within every issue? Or do you have to or is your position that you have to have predominance with respect to every discrete issue that's raised?
The predominance inquiry begins with the underlying elements of the claim, and here where economic loss is one of those elements, that needs to be scrutinized under the predominance inquiry.
So your position is that you have to have predominance with respect to every element, not just predominance overall amongst the elements.
Well, this court has held that in response to the Private Securities Litigation Reform Act of Congress that there needs to be a heightened pleading standard for these elements of the claim.
But we're struggling with the question that you can think about predominance in a number of ways. You can think about predominance from 30,000 feet and say across the whole case you've got a lot of things in common. Or you can say within each pillar, each element, you don't have to have 100%, but you have to have predominance in each pillar. And the fact that there is a lack of predominance in the damages is a problem, even though you have predominance in the other 3. Is that how we should be interpreting the predominance rule?
No, Your Honor, not every single element needs to be this heightened scrutiny as you're suggesting. However, petitioner put this individual question, damages question, at the center of this claim with their theory of liability and this consequential damages model. And here, it's less important that all the investors, for example, relied on this misrepresentation. The more important question is whether investors would have chosen to divest or invest with the heightened risk, because this relates directly to their theory of damages and their theory of liability. And while this court has held that individual damage calculations do not necessarily per se preclude certification, Justice Kennedy noted that in Tyson Foods that if there's no way to ensure that the jury's damages only go to the injured class members, then the award cannot stand, and that needs to be addressed at the certification stage. Because, as Your Honors have noted,
remember, does Comcast go on this predominance? Is that the sort of framework that it used in that case?
Yes, Your Honor. They were looking to a
so is that maybe part of the problem of Comcast that's causing the confusion? Is it seems like it's not really a predominance question. Like the consistency of the damages model with the liability is a problem, one that we should look at. But maybe predominance is sort of the wrong lens, and that's why we caused so much confusion in lower courts is by putting it in the wrong framework. Is that possible?
No, Your Honor. As it stands today, Comcast says what it says, that the theory of liability needs to be consistent with the theory of damages, and the damages model must be sound and produce commonality of damages. And here, where there's a consequential damages model that cannot be applied to each investor, it cannot be used to produce commonality of damages.
But that whole argument, that's a nice little argument that you just made, but you didn't even need to use predominance there, right? So maybe it's a great argument, and maybe we have the right holding in Comcast, but maybe predominance isn't the right framework to be thinking about here.
Well, under Rule 23b3, the class can only be certified if individual questions are not predominated or outweighed by these common questions. And here, the big issue here, the question is whether each investor would have invested had they known of this heightened risk. And when it's necessary to perform an individual inquiry and to answer that question, the common question is not going to be resolved, and that is why Comcast applies to this 23B3 and in this case. And further, under the theory of damages, each investor is going to have to bring individualized proof that they would have not invested in order to be entitled to these consequential damages. And with these individual trials is exactly the reason why class certification is such an inquiry, because we cannot go forward on this trial if we have to do these individual inquiries. And
But isn't that the, I mean, that's to be sure a problem, but it's a kind of problem that happens a lot in securities litigation. And didn't we say in Halliburton and in much of our jurisprudence that we don't want to so micromanage class certification that it becomes impossible to bring a class action in securities fraud litigation? We have an incentive toward certifying classes.
yes, Your Honor, but however, this, as Congress noted, that the Private Securities Litigation Reform Act intentionally made it harder to initiate 10b-5, and I see my time is up. May I briefly answer and conclude? That there needs to be a heightened pleading standard because of the abusive practice of they had seen in these 10b-5 causes of action. So they intentionally wanted to raise the standard that plaintiffs have to affirmatively demonstrate their compliance with Rule 23, and because they provided no mechanism for ensuring that that uninjured class members would not be able to recover, that it cannot stand here as it is here today, and therefore class certification is improper. Thank you.
Thank you.
Your Honors, if I may begin with a quote, and I apologize for looking down, but I want to ensure I get this right. Rule 10b and 10b-5 make it clear these anti-fraud mandates are intended to protect purchasers of securities from sellers' misrepresentations that later lead to losses that are realized in the value of their purchase. Your Honors, this was this court's language in Dura in 2005, which respondent repeatedly stated led this court to potentially not accept materialization of the risk in today's case. However, that quote clearly states that a 10b-5 action was enacted for this very type of action, to protect investors from fraud perpetuated
But
by...
does materialization of the risk necessarily require a consequential damage award? I know your expert Kaufman has said that. It doesn't require that, though, does it? You can protect investors without going all the way to consequential damages, correct?
Your Honor, you can protect investors that potential way, but in this specific instance, we believe that a consequential damage model in this instance is proper.
Right, this is the most, but that's not necessarily... You can't. Are you going to stand in front of us and say that everybody in your class is of the sort of investor that would not have invested, but had they known of the risk?
Your Honor, I believe as my co-counsel stated, we're assuming that there are two classes in this case, and at this stage, the proceedings, that we believe it would be proper to remand this proceedings to the lower court so they could properly certify a class and look at it on an individualized basis. For the foregoing reasons, we believe this court should adopt materialization of the risk and find a corrective disclosure is an inadequate way of proving loss causation, as respondent can avoid liability. Thank you very much.
You may be seated. Congratulations. That was, the arguments were exceptionally good. You were outstanding. You should all be extraordinarily proud to have made it this far, but with all of the changes and the sitting before such a distinguished bench, not the distinguished bench you had in mind, but we're all glad to be appellate judges now, because that's what your program is. So we are delighted to have been here today. It was a great way to spend a Friday noon. You did a great job. It was really extraordinary. So we are going to take a moment to give a little bit of feedback, but you're this far, you've heard a lot of feedback, so we're not going to nitpick it, but we're going to give you a little bit of feedback on your arguments today, and then we are going to announce the winning team and the best oralist after we give you some input. I'm going to start with Justice Lund.
Well, I just reiterate what Chief Justice Brogan suggested. This is it's kind of an area that I know a little bit about, and it's not easy. I suspect it's probably one of the more difficult problems that we've had at the Moot Court and the Reimels for however many years. So the fact that you've made it this far with such a difficult problem, I think, is really you should consider it exceptional. Just to sort of. Most of these comments sort of apply to everybody. I just kind of wanted to, I think at some level, the folks who went second had a harder time because that question about certification and predominance and the loss causation models and things like that is probably less intuitive than the first part. And I think each of you did very well. And in particular, I wanted to mention Ms. Wernitsnik, right? I sort of at the end, at the very beginning of I offered you an answer, which I honestly think is the right answer, but it was one that gave you an option of either saying yes and really changing the path that this case goes on, or saying no and fighting. And that's a choice you're gonna have to face all the time in front of a bench. And you, I think, made the right choice. And it was a risky choice. And so that takes courage, because most people, we tend to just sort of continue to do what we planned on saying the whole time. And so I want to sort of commend you for that. That was really pretty exceptional. And that's, Mr. Rivera, I thought that was, I thought you had you had the toughest one. You did. You have the toughest case. Because the counterfactuals that we all came up with are just so apparent. And I thought you were ready for them. And despite having a very combative bench, you kept a good demeanor, and you were willing to sort of play with us and not feel too aggrieved. Mr. Zlotnick, I thought you did a great job. I thought the facility with which you used the record. This is also true with you, Ms. Huber. You both used the record and referred to the record. Ultimately, this is not really a record base, too much of a, but the sort of the ease with which you referred to it, I thought was really exceptional. And I thought you both, particularly you, Ms. Huber, you used case law well. You clearly were aware of cases, and I thought they fit in well with your comments.
Justice Agar.
All right, so I'll be even shorter because I agree with everything that Justice Lund said. I thought we were throwing a lot at you, Kaylin, from all different angles. I think in many ways maybe you had the least predictable questions, in part because we had got through the easy questions with other people, so by you we were just like throwing, what about this, what about that? And you handled it, right? And that, I think that was really well done, and so really nice job. I mean, all four of you just really kept your composure in a really nice way. I mean, to you it probably feels like, oh yeah, what else would I do? But go see some real arguments sometime,
Right.
and you'll see what people think of all sorts of weird things to do while they're arguing cases. And you did none of the four of you did any of them, so that was great. Rodrigo, yeah, I mean, those were. Kaylin's questions were more weird maybe than the ones that you got. But yours are just like, what am I supposed to say to that, right? And I thought that you had every argument that I could come up with, you said, right? And bringing in, and what I particularly liked about some of your arguments is that they're not like something that you would necessarily like. It's not a legal response per se, right? Like some of these are sort of like policy responses, of like, we're going to get pushed into settlement regardless of whether there's true liability. About that whole point about regaining the trust, and that's why you would disclose anyway. I mean, those were good points. They were the best you could do, and some were better than I came up with. So I thought that was quite well done. Scott, great job. You started off the argument with a lot of you just set the tone for everybody by just standing up there and just being very confident, projecting everything, knowledge of the cases, knowledge of the record. It just that has to feel good to really feel like I know this stuff, right? Like there's so I thought you did great with that. And Vanessa, you were everybody was unflappable, and you were sort of particularly unflappable. You just stood there and took it, and again didn't waver, you just responded to the questions. And I thought, and that's so hard to do because it's really frustrating. And all four of you are in over your heads, which you kind of are as a litigator, right? Like that's just what you do. The only thing that actually, we were a better prepared bench than you maybe would often find. And so I think the one thing that if we were truly testing you, we would have asked a completely wrong question that misunderstands the entire case. And we did spare you of that. So we may have been mean to you in other ways, but we were a little less ignorant than maybe many benches would. So, but great job, all four of you.
So incorporate by reference everything. I agree wholeheartedly with everything that Professor Lund and Dean Agard said, you guys were great. I agree. You had a tough, like we were hot by the time we got to you, and you handled it with grace. Rodrigo, I think you, especially once you got into it, not only did you have knowledge, you all had knowledge. You moved around the cases and the facts, the record, the social policies. You moved very facilely among all those things, and I think that's important. You had a warm back and forth with it, and especially as you got into it, you had a way of engaging with the person asking you the question, but also sweeping the rest of the bench in, and not standing your ground. And you all did this, standing your ground without getting aggressive. I thought that was, in addition to everything else that's been said, I think that your demeanor with the bench is exceptionally good. You all had a very professional demeanor. You never let us get you angry, and we've all seen that, where somebody gets a little aggressive, a little overly aggressive, because that's not the question, or you're asking too many questions, or you won't let me answer your question before you interrupt me. None of you fell for that, and as we've said, this was a hot bench. Vanessa, I thought you just had that confidence of moving around, knowing the record, calling our attention to things, correcting without being a school marm. You did a very, very nice job of that, very professional. Scott, I agree. I think Todd said it when he said you set the tone that everybody else followed. You stood up and you knew what you were doing. You knew the cases, knew the record. You used, without awkward quoting, all of you did, without awkwardly quoting, you used the record and pointed us to the record, corrected us, all of you again, for the most part. When we did get a little bit off, you corrected us and drew us back. I thought that was really good. I liked the one thing you said when you said our job is to prove plausibility. Like, you got us off the nitpicking right from the get-go, and I think that was really important. I think, there's a tough argument on either side, and I think you guys handled that with grace and with authority, and I'm impressed and think that you guys did a fabulous job. I think you should be very proud. I will say, and we'll get into announcing, anything else you guys wanted to add? I hear this often, not always, but it's very difficult to make this decision when you get this far, and it should be, when you get this far and you've been through the sifter a number of times. I have heard, and not us, but a lot of us have seen oral arguments. You guys are better than most of the oral arguments that are going on in many of the appellate, not the Supreme Court.
But you're better than some Supreme Court arguments that I've seen.
And you're light years better than many, if not most, appellate advocates. You did a phenomenal job, and I'm so proud of each and every one of you. Because unlike the other judges, we get to say we're really proud of you. You guys done good. We have to, and I'm not going to do the Miss America speech, but we do have to, I am going to thank the legal writing instructors here and Jess Webb, the people who got you here. You did it on your own. It's your own talent is why you're here, but you had people who, the legal writing program here is extraordinary, and this is proof positive. Professor Booth for a devilish problem. Thank you very much. I know more about securities law than I ever want to know, but who knew it was torts? I didn't say Paul's graph because I didn't want to cause Rodrigo to have a heart attack, but it's all good. So, in announcing our winners, why don't you announce the overall winner and you announce the best oralist? Overall winner.
So overall, the Zlotnick-Huber team was the
All really, really close, but Scott Zotnick is the best oralist.
And one last acknowledgement, if I may, to the Moot Court Board. The Reimels ran completely smoothly, except for the, act of God, the weather event. The grace and cheer with which you managed yesterday afternoon, last night, and this morning, and all being here dressed up in suits on a Friday. Thank you so much. But kudos to you, the work you do ongoing with the Reimels and with the outside comps. You guys are the best, and we appreciate what you do. We're proud of you all too, all of our students. So thank you very much. And now,
Reception.
reception downstairs in the reception.